Hello, I'm Grace. Banks will no longer be permitted to include various statutory costs, which have long been added to interest rates, when determining loan rates. According to an amendment to the Banking Act by the Financial Services Commission, FSC, the government's top financial regulator, banks will be prohibited from incorporating mandatory legal costs into their spread or additional interest rates starting next month. Previously, items such as contributions to the Korea Inclusive Finance Agency have been included in these spreads, acting as a factor that increased the interest burden on consumers. Reports indicate that while reserve requirements and depositor insurance premiums have already been excluded from interest rate calculations since early 2023, this amendment formally codifies them as prohibited items. In particular, for loans secured by guarantees, banks will no longer be able to pass on more than half of their contribution costs to interest rates, and for loans unrelated to guarantees, passing on the full amount will be strictly prohibited. Furthermore, regulations have been strengthened to prevent the increased education tax rates applied to financial institutions, following amendments to the Education Tax Act, from being included in loan rates. Compared to past practices, this measure is significant in that it institutionally blocks the custom of banks shifting public costs onto their customers. In the past, there was a clear tendency for legal costs to be hidden within the ambiguous category of spreads, placing a real financial burden on consumers. The core impact of this amendment lies in the direct reduction of interest costs for borrowers using guaranteed loans or those affected by the increase in education taxes. A fact check reveals that the focus extends beyond simply lowering interest rates. It is aimed at ensuring fairness by making the interest rate calculation structure itself more transparent. This change is intended to break the practice of banks utilizing costs incurred from fulfilling legal obligations as part of their profit models. Moving forward, banks must review their own interest rate calculation methods at least twice a year, record the results, and manage them strictly in accordance with internal control standards. Financial authorities also plan to continuously monitor the interest rate calculation process to ensure that banks do not revert to past practices by including legal costs. These regulations will apply immediately to all loan contracts signed or renewed after the 1st of next month, thereby protecting consumer rights. Ultimately, this measure is expected to serve as a turning point that resolves opacity in the loan rate determination process and eases the actual economic burden on financial consumers. I'm Grace, thanks for watching.